Marbury.
Judicial review and wily Odysseus at work. Marshall is very clever. He's right on the big issue, but keep your eye on him. He will pick your pocket.
Burr trials.
Under-attended to, because it's a circuit court opinion, very important affirmation of constitutional liberty, rights of defendants, and oh, he's sticking it to Thomas Jefferson.
Dartmouth.
An important affirmation of basic rights of private property, limited government, development really of a third sector of the economy, the not-for-profit sector.
McCulloch.
Most important for how it approaches the Constitution. What it says, broad federal power, right, but Marshall has a certain way of approaching the Constitution holistically that is McCulloch's greatest contribution. Not just what the Constitution means, but how we read it.
Gibbons.
A great New York case with an amazing New York cast of characters from Fulton and the Livingstons, and there's a Vanderbilt in there. An important affirmation of federal power to regulate things that involve more than one state.
Antelope.
A reminder that their world was very different from ours. They lived in a world, Marshall did, when slavery was a dominant feature not just in America but in the globe, and international law protected the slave trade, and Marshall pays attention to international law.
Cherokee cases.
Federal supremacy over states in dealing with Native Americans. William Marbury was a Federalist. He was an ally politically of John Marshall and John Adams, and he wanted a piece of paper. He wanted a piece of paper called a writ of mandamus. Now, what's that? That's a piece of paper issued by a court telling someone what to do. The mandamus that William Marbury wanted was from the Supreme Court. He wanted them to issue this piece of paper to James Madison, the Secretary of State, so that Madison would issue another piece of paper, a commission. And the commission that Marbury ultimately wanted would say, you, William Marbury, are a justice of the peace. So he really wanted two pieces of paper, one from John Marshall's court, a writ of mandamus, ordering James Madison to issue this other piece of paper saying that Marbury actually had been properly appointed as a justice of the peace by John Adams. He doesn't quite get the piece of paper he wants. Instead, he gets a third piece of paper. He gets a piece of paper from John Marshall saying, you know what, I'm not going to issue this writ of mandamus, but you're a justice of the peace. And it was a very clever move on Marshall's part, because that third piece of paper, the opinion of the court, can't be defied by James Madison or Thomas Jefferson the way the piece of paper that Marbury actually wanted, the mandamus, could have been defied. What Marbury wants is for the world to know that he actually was appointed at the end of the Adams administration to a position, to a justice of the peace position. He's appointed, but he doesn't receive, at the end of the Adams administration, in all the chaos, he doesn't get his commission suitable for framing. Just like you get a diploma. You work hard for 4 years at some school, and you want to sort of hang up your diploma. That's what he wants. He wants his commission. And Adams had issued it, and it had been basically sealed by the Secretary of State at the end of the Adams administration, a Secretary of State known as John Marshall. But the paper never got delivered. The commission never got delivered in the confusion at the end of the Adams administration. So Marbury would like his commission. Thomas Jefferson, though, is now president, and he said, well, it might be in my files here, but I don't actually really want you to be a justice of the peace, and I'm president now. So Marbury goes to court, and he wants the court to basically tell the new administration, the Jefferson administration, that they have to issue this commission. And that's what he wants. And Marshall is worried that if he tries to do that, Thomas Jefferson will just look at him and say, well, you and what army? I'm not giving the piece of paper. I'm not issuing the commission. What are you going to do about it? So Marshall is in a bit of a bind here. And he, like Wile Odysseus, like Indiana Jones, he manages actually to basically escape this dilemma he's in. Here's the dilemma. On the one hand, if he issues the commission, Thomas Jefferson and his Secretary of State, James Madison, will just laugh at him. And judges don't like to be laughed at. On the other hand, if he does nothing at all, he's a wimp. He's given up. He's abandoned his political allies. He's basically just caved to the Jefferson administration. So here are your choices. Just defeat, being a wimp, or actually fighting this fight that you can't quite win because it's going to be very difficult for you to tell the President of the United States whom he has to have in his administration. Marshall finds a third way out. And the brilliant way out is to say, I'm not going to order anything from Thomas Jefferson, but only after I've told the reader in this opinion how Thomas Jefferson has behaved disgracefully and unlawfully, and this commission really should be issued, and my friend William Marbury really is a justice of the peace, but I don't have jurisdiction to say so. That would have been brilliant enough. But he adds, as the pièce de résistance to this brilliant performance, oh, and the reason that I can't issue the writ of mandamus is that Congress, which has passed a law that I, John Marshall, say allows me to do this, that's an unconstitutional law, and I'm not going to follow an unconstitutional law. Everyone is expecting that the battle is going to be between the judiciary and the executive branch. The bull is so John Marshall is waving a red cape at this charging Bull Jefferson, and Jefferson is about to gore Marshall. That's what everyone's for. And at the last minute, Marshall pirouettes, the bull passes, which would have been brilliant enough. But then he turns around, Marshall does, and asserts power against Congress, even as he avoids this fight that he can't win against the executive branch. Now, some people say, oh, he made up that last bit. Federal courts aren't allowed to disregard acts of Congress. I don't think he made that up at all. That was actually well established before Marbury v. Madison in American law, but he uses this case as an opportunity to cement that. So he's actually retreating. He's avoiding a fight that he can't win with Jefferson. Oh, but what a glorious retreat it is. It's with trumpets and fanfare, and it's an utterly orderly retreat, and from really the jaws of defeat, he snatches this extraordinary institutional victory vis-a-vis both the president, whom he shames but does not confront in a way that he can't win, and against the Congress. Jefferson is outraged by the decision because he thinks Marshall has just said all sorts of stuff that he had no business saying. This was, in legal parlance, dicta. If you don't have jurisdiction, then what's all the rest of this opinion doing when you're basically just shaming me and browbeating left, right, and center? So he does not love it at all. But there's not a lot he can do about it because Marshall, in a Seinfeldian sense, has done absolutely nothing. He hasn't issued any order whatsoever. And had Marshall issued the order, here basically are the three possibilities. Best case scenario, you tell Jefferson he's got to issue this commission. Best case scenario, Jefferson ignores you. Madison, the Secretary of State, on Jefferson's orders, ignores you, and you look like a wimp. That's the best case scenario. Second, even worse than that, and it's a real possibility, is Jefferson will try to get his friends in Congress, and he has more votes in Congress than Marshall does, to impeach John Marshall and maybe other justices for judicial overreach, judicial activism. And there are already, at this moment, impeachment noises being made again about another justice. Worst case scenario, well, you know, there's this thing called the French Revolution, and heads did roll, and we know that heads don't roll in America. But can Marshall be absolutely sure that won't happen? Thomas Jefferson has said all sorts of things about the French Revolution. Well, you know, you can't really have an omelet without breaking a few eggs. And now, we know that Jefferson isn't quite a crazy man, but can John Marshall be absolutely sure of that? His court is quite weak at the time. Jefferson is quite strong at the time. Jefferson controls not just the presidency, but basically the Congress as well. So do you want to pick a fight with a very powerful president that you can't win? Aaron Burr was at one point the running mate of Thomas Jefferson. And Jefferson thought that Aaron Burr was basically running to be vice president, to be Jefferson's vice president. And that's pretty much what everyone else thought. Back in those days, though, technically, you couldn't run for vice president. You had to run for president and come in second, in effect, and that's how you became vice president. Well, Thomas Jefferson and Aaron Burr think they have an understanding, or at least Jefferson does, that I'm going to be president and Burr is going to be my vice president. The only problem is when all the ballots are opened, Jefferson and Burr end up tying because everyone who voted for Jefferson also voted for Burr. One person was supposed to basically throw away a vote. It didn't happen. Now, if Burr had been the kind of person that Jefferson thought he would be, Burr would have basically said, oh, listen, I was supposed to be second fiddle, and I renounce any claim I have to the presidency. I ask the Congress, which is tallying these votes, to anoint Mr. Jefferson. Burr doesn't quite say that, and that annoys Jefferson. Burr doesn't say, oh, vote for me, but he doesn't quite say, oh, it's Mr. Jefferson's position. Burr basically maintains a kind of silence on the thing, and now technically Jefferson and Burr have tied for the presidency. And the decision is now thrown into the Congress, and Jefferson's party doesn't control the Congress altogether. So the Federalist Party, the party that's basically lost, John Adams was the incumbent, he lost, but some of his allies, some of Hamilton's allies, some Federalists, some anti-Jefferson folks are going to be the key decision maker. Which are they going to pick, Jefferson or Burr? They lost the election, but they still have the ability to basically make some mischief by picking Burr over Jefferson. So Jefferson and Burr were initially running mates, but very early on there's a rift between them. At the end of the day, Alexander Hamilton tells his friends, listen, you should vote for Jefferson. There's no one who dislikes Jefferson probably more than I do, and there's probably no one who is disliked by Jefferson more than I, Alexander Hamilton, am. But Jefferson has principles, and Burr has none. So Jefferson is more trustworthy because he actually does believe in things. And Jefferson, once he's president, actually will believe in national power and presidential power far more than when he was in the opposition. So we should throw our support, we Federalists, to Jefferson. And thus is, if not the beginning, at least one important rift now between Burr and Alexander Hamilton that will result in an encounter, an appointment at Weehawken, in which, in a duel, as everyone knows, Aaron Burr kills Alexander Hamilton. This is the sitting Vice President of the United States. Remember, he's not president because Hamilton has thrown his support to Jefferson, and now Jefferson is president, Burr is vice president. Burr is not really beloved by Jefferson, and he's not beloved really by the Federalists either, and now he's killed the great Federalist champion, John Marshall's hero, Alexander Hamilton. He's killed him in a duel, and this is the sitting Vice President of the United States, you see. And he's under indictment, actually, in 2 different states for homicide. In New Jersey, where the duel took place, and in New York. He's a New Yorker, as is Hamilton. And he continues to preside as vice president over the Senate. That's what vice presidents do. They preside over the Senate. There's an impeachment trial of a Supreme Court judge, a Supreme Court justice, named Chase at this time. And who's the presiding officer? It's Aaron Burr, leading newspapers to say, well, in most countries, the murderer is arraigned before the judge. But here in America, we have the judge being arraigned before the murderer. Now, that's all backstory for the Aaron Burr trial. Jefferson runs for re-election, and does he pick Burr as his running mate the second time around? No, he does not. Been there, done that. He does not trust Burr. So Burr now is no longer Vice President of the United States. He's killed Alexander Hamilton in a duel. The Federalists don't love him. The Jeffersonians don't love him. He's a very talented person. He's American royalty. His grandfather was the great Jonathan Edwards, America's greatest theologian. His father, Aaron Burr Sr., was president of Princeton University. He's in the elite, but he's a man without a party, a man without principles. What's he going to do? He's got a lot of energy, and so this is before Horace Greeley has come along, but he goes west. Of course, Greeley famously says, "Go west, young man." So he goes west, and the question is, what actually is he doing out in the West? The accusation is that he's creating an army of his own. He's working to maybe actually create a Western republic that will break away from the United States, grab some land from Spain as well, and he's going to set himself up as a kind of American Napoleon. That's the accusation against him, and Thomas Jefferson, who is still present, is very willing to believe every piece of dirt, every piece of gossip that's reported to him about Aaron Burr, because he doesn't trust Aaron Burr at all, and so he initiates a treason prosecution of Aaron Burr. Now here's the final kicker. The trial is held not in the Supreme Court, it's held in a lower federal court, but at that time, lower federal courts were often presided over by Supreme Court justices riding circuit. Now, who should be the presiding officer in this trial? None other than John Marshall, who has a complicated, to put it mildly, relationship to Thomas Jefferson. So the fate of Aaron Burr, Thomas Jefferson's now archenemy, is going to be decided by John Marshall, who is not Thomas Jefferson's best friend. Burr is on trial basically for his life. And he says, look, I'm innocent. I didn't do it. And Thomas Jefferson has information in his files that actually shows that I'm innocent. Surely, as a defendant, I have to be able to show that I didn't do it. So I want you, Mr. Chief Justice, may it please the court, sir, I want you to basically subpoena the president to provide exculpatory information. Today, we would call this Brady material. Brady material is a reference to a modern Supreme Court case that says if the prosecution has in its possession information that tends to exonerate, that tends to exculpate a defendant, to show that he might be innocent, they have to share that with the defendant. They can't hide that. So today we would say this is a simple Brady case. Jefferson says, I'm President of the United States. I have a lot of sensitive information, diplomatic information. I don't lightly want to have to make public, for example, my intelligence sources, where I've gotten certain information, with whom we've been speaking in the Spanish government or the Mexican government or the French government or what have you. This is, there may be some information in my files, but it's very sensitive national security, diplomatic secret stuff. And you can't force me to actually disclose that. So John Marshall is faced with a difficult choice. On the one hand, if he tells Thomas Jefferson, you have to release this information, there could be serious national security consequences. On the other hand, Mr. Burr's entitled to a fair trial. Here's the beautiful finesse, legal finesse, that John Marshall shows. He says, Mr. Jefferson, if you want to prosecute Burr, you have to give him the information he requests, because it's just not fair to withhold exculpatory information. But there's nothing that says you have to prosecute Burr. You can drop the prosecution. And prosecutions are dropped all the time for all sorts of reasons. We call it prosecutorial discretion. It actually really, when you think about it, is non-prosecutorial discretion. It's the discretion not to prosecute. And there are 1,000 reasons why prosecutors every day choose not to bring charges against people who might even be guilty. So the Burr case is later invoked in another famous trial, the United States versus Nixon case, in which Chief Justice Burger says, oh, we can force Richard Nixon to hand over certain tapes, certain confidential communications in the Oval Office, and the precedent is the Aaron Burr trial. Think about it, you're Warren Burger. You're looking around for a good precedent, and not only do you find a precedent, it comes from John Marshall. You can't get any better than that, and Burger plays this with flourish. I'm just doing just what John Marshall did. I'm telling Nixon he has to hand over this information. But it's not the same at all. Burger completely misread Burr, and so did all the other justices. It was a unanimous opinion in the Nixon tapes case. Because in the Nixon tapes case, who was asking for the information? Not the defendant. It was actually the special prosecutor, and Nixon didn't want to hand over the information. And he's the prosecutor in chief, and so if he doesn't want to hand over information that shows someone is guilty, why isn't that his call? So it's totally different than the Burr case, but 8 justices missed that point in the famous Nixon tapes case. Another important aspect of the Burr case is that John Marshall has a very strict standard for what counts as treason. Treason isn't just loose talk. It requires taking overt actions. And those overt actions, so it would require, for example, actually summoning an armed force and actually gathering, meeting. And it requires 2 witnesses to testify to that same overt act. We have stricter rules about treason in America than England does. And these stricter rules come not merely from a statute, from the Constitution itself. The Constitution defines treason. And it's in fact the only time in the entire Constitution that the word only appears. It says, treason shall consist only of levying war against the United States and giving aid and comfort to their enemies. So what's that only doing there? It's like a Bill of Rights, even though it's in the original Constitution. It's saying, here's what can't count as treason: criticizing the government. So the treason clause is a First Amendment, avant la lettre. It's a protection of political speech. Oh, and it's also a Bill of Rights for criminal defendants, criminal procedure, because it requires 2 witnesses to the same overt act or confession in open court. So even before there's a Bill of Rights, the original Constitution, in its very strict definition of what counts as treason and its special procedural rules, is trying to limit government abuse. And John Marshall has a very strict understanding of what counts as treason, and that favors Burr on the facts of the case. And Jefferson doesn't like it at all. Now, Jefferson's a great civil libertarian sometimes. When his friends are being prosecuted by John Adams for criticizing the government, oh, Thomas Jefferson waxes poetic about the importance of free speech principles. You have to be able to criticize the government. But Jefferson, when he's in power, can be a little thin-skinned, as Adams was when he was in power. And John Marshall actually renders a civil libertarian decision when he has a narrow definition of what counts as treason. In so doing, he's actually protecting political expression. Merely criticizing the government, even mouthing off against it, isn't treason. And until Aaron Burr has actually done something, he shouldn't be convicted of treason. Dartmouth College is a small school, but there were those who loved it. That's a line from Dartmouth's most famous alumnus, the great Daniel Webster, who actually, in an assignment of a lifetime, gets to defend his beloved alma mater in the United States Supreme Court, and not just defend it in just any old case, but in a case that basically is really an existential case for Dartmouth College. Is it going to be allowed to exist? And its great alum, Senator of the United States, great Supreme Court litigant. Daniel Webster argued more than 100 cases at the United States Supreme Court, but maybe he cared more about this one than any other case because it was about whether his school, which he did love, was going to be allowed to exist. In a nutshell, in 1769, Dartmouth College got a charter, a piece of paper from the British government saying you have a right to exist and to run a charitable institution, an eleemosynary organization. So they had permission to create this school. After the American Revolution, the king is gone, the British government is gone, but the former colony, now state of New Hampshire, basically confirms that right of Dartmouth to exist. New Hampshire basically steps into the shoes, as it were, of the charter granting a British government and stands by that charter, or it did for a while. At a certain point, New Hampshire takes a look at Dartmouth and says, gee, that's a kind of nice school they got there. Wouldn't it make a great University of New Hampshire? Why don't we just take it over? And there's some factionalism going on, actually, within Dartmouth. There's one group of faculty and alums on one side and another on the other side. Why don't we side with the insurgent faction, get them on our side, take the thing over, and make it into the University of New Hampshire? And Daniel Webster, representing the old trustees, goes to the Supreme Court and said, they can't do that. No takebacks. They've given Dartmouth a proper charter, and they can't take it back. There are rules in the Constitution about how contracts can't be violated by the government. And this charter is a kind of special contract that New Hampshire made, and before it, the king made with this school. And the school has kept its end of the bargain. So New Hampshire can't just take it over. That's, to use a more modern word, socialism. You can't do that. And the deep principle of the case is actually a principle about the importance of private property, a private sector, a non-governmental sector that the government just can't take over at will. And so it seems like a very technical little case, but let me take a big step back and show you how significant it is. Lawyers talk about a thing called the state action doctrine. And by that we mean that constitutional principles generally apply against the state, against the government, but not against private individuals. That might seem really technical, except when you really start to think about it, because the very thing that governments can't do, individuals can do. And so you have to have a sense of when the government ends and when individuals begin. Government can't have a religion, but individuals have to be able to decide, I want to be a Christian, I want to be a Jew, I want to be an agnostic. So the very thing that government can't have a policy on, individuals get to decide. Government can't be Republican or Democrat, but an individual gets to decide, I want to be a Republican, I want to be a Democrat. If I want to open up a printing press, the government can't open up a press that just spews out Republican propaganda, but a private person should be able to open up a printing press and just present Republican points of view. The very thing that the government can't do, private institutions and persons should do. If I want to open up a magazine that's only for conservatives, that's my right to do. I can call it the National Review or anything else. Government can't do that, but individuals have to be able to do that. And they have to be able to use the corporate form in doing that, because otherwise, basically, they can't use something that everyone else has access to. It would be like saying, oh, you have a right to be a Republican unless you want to drive on the public streets. And then, since you're driving on the public streets, you can't be a Republican. Oh, well, you have a right to be a Republican unless you want to open up National Review, Inc., and then you can't do that. So the Dartmouth College case is just because you're a corporation, the government doesn't own you, can't take you over, can't treat you as an extension of the state of New Hampshire. You are not the state of New Hampshire. You're in the private sector. Just because the government gave you permission to incorporate doesn't mean that the government basically then controls you thereafter for all purposes. The New York Times Incorporated has to be independent of the government, or the National Broadcasting Corporation, which we call NBC, or MSNBC, or Fox News. Those entities have to be able, even though they're corporations, to be independent of the government. And now you see how hugely important this little technical case called Dartmouth College is, because if it's decided the other way, if the government at any time can take over any corporation because it doesn't like its message, there's a lot less freedom in America. So it's not just about private property. It's about, I would say, free speech and free press as well in some really important ways. It's about a not-for-profit sector, an NGO sector, which is, in America, a huge part of our society. There are individuals, there's the government, and in between, we actually have a very robust charitable sector of schools, of churches, of political parties and other organizations. And at the bottom of all of them, and their right to exist, is this case called the Dartmouth College case. The Second Bank of the United States was chartered during the War of 1812. It's the second bank because there had been an earlier one chartered when George Washington was president, backed by Alexander Hamilton, opposed by then Secretary of State Thomas Jefferson, by his ally in Congress, then Congressman James Madison. So Jefferson and Madison had opposed this first bank that Hamilton backs and eventually persuades Washington to endorse. And that bank lapsed. And now we're in a war against Britain. And some people think that this bank is actually helpful in winning a war. For all sorts of reasons, it's very good to have a central bank. And so there's a move afoot to recreate the bank, to create a second Bank of the United States. Now, who should be president at the time? None other than James Madison, who had been the chief opponent of the bank in the Washington administration. So what's Madison going to do? Well, Madison, in the end, signs the bank into law. And that's the second Bank of the United States. But there are those who think it's unconstitutional, making arguments that Congressman Madison had once made, that Secretary of State Jefferson has once made. So now the case goes to the Supreme Court whether Congress can actually create this bank, which Congressman Madison said it couldn't, but President Madison said it could. William McCulloch was a local bank officer in the state of Maryland for the Bank of the United States. And Maryland has passed a law imposing a tax on out-of-state banks, banks that haven't been chartered by the state of Maryland. And oh, what a coincidence, there's only one bank that this applies to, and it's the Bank of the United States. And the tax is to be collected from the bank agent, the bank agent, Mr. McCulloch, and if he doesn't pay, he's going to be put in the pokey. And he thinks Maryland can't do this because it's a properly federally chartered bank and states can't undo what the federal government has properly done. So the case eventually gets to the Supreme Court. In Maryland, Mr. McCulloch loses. The case is actually Maryland v. McCulloch, People v. McCulloch, State v. McCulloch. He's the defendant. He's supposed to pay. He doesn't pay. And the state courts side with the state government, which, speaking of paying, pays the state judges. So they side with the state law, the state judges do. McCulloch takes what we would say today, call it an appeal, but McCulloch brings the case up to the United States Supreme Court, which sides with him. And there are two questions in the case. First, can Congress properly create a bank? Congressman Madison thought no. President Madison, I guess, thought yes. He signed the second bank bill into law. So that's the first question. Can Congress properly create a Bank of the United States? And the second question is, assuming that Congress can, may states tax that bank? Marshall sides with the bank on both questions. The bank has to win on both questions. If it loses on either question, it loses. So it has to persuade the court, and it does, and the court is unanimous. First, the Congress does indeed have power to create a national bank. And second, that Congress having properly created a national bank, states can't destroy that national bank. And if they have a power of taxation over a national bank, that would, as a practical matter, lead to the possible destruction of the bank. So the bank wins on both questions. That's actually not the most interesting part of McCulloch versus Maryland. The most interesting part of McCulloch versus Maryland is why the bank wins, how Marshall chooses to explain his result, because he explains it in a way that President Madison does not like, even though Madison signed that bill into law. First, Marshall says, look at the Constitution as a whole. Don't look at this clause or that one. In fact, he doesn't place emphatic reliance on the necessary and proper clause, as most people believe. Marshall has decided the case in favor of a federal bank before he says a sentence, a word about the necessary and proper clause. And the necessary and proper clause standing alone could never do the work because Congress has power to pass laws necessary and proper to something else. Necessary and proper clause at most is a leash. It's an extension cord. It has to be anchored to something else. If I go into a coffee shop and I say, how much is a cup of coffee? And they say $3. And I say, how much are refills? And they say, refills are free. And I say, okay, I'll have a refill. No, that doesn't work, okay? You can't use the necessary and proper clause unless it's connected to something else. And Marshall actually never quite tells us very specifically what the other clause is, because he's not playing a little narrow textual clausal game. Here's what he's doing. He steps way back and he says, what's the whole point of the Constitution? Why did farmers and merchants and sailors and everyone at the time of the Constitution, why did ordinary people vote for this big, stinky federal government after having fought a revolution against a big, stinky, faraway government in London? Why did people do that? Let's look at the Constitution as a whole. Answer: for national security. Because we needed to be able to beat the British, and Massachusetts on its own can't do that, and Maryland on its own can't do that, and Virginia on its own can't do that. Step one. The Constitution was created for national security. Step two, a bank is pretty darn useful, a national bank for national security purposes, to borrow money from abroad, to move money around. It's a vast country. You've got to move the army north and south and east and west. You've got to pay them on time, on site and on time, because if you don't, they may desert. They may mutiny. They may die if they don't have the resources on site and on time. So it's an ATM argument for a bank, having a national bank with branches everywhere. Step one, people voted for the Constitution for national security. Step two, bank is pretty darn useful for national security. Step three, pretty darn useful is good enough for government work. That's enough for a document designed for ordinary people. I'm not going to look at this, this clause or that clause. I'm going to show you how it fits the specific words, but the big argument is a structural argument. Now, here's why Madison doesn't love this argument. Madison wins. He's signed the bank into law. But Marshall, on 2 occasions, goes out of his way to basically say, oh, my man Hamilton was right the first time around, and Jefferson opposed it, and Madison opposed it, and they're flip-floppers, because now they're supporting it, but they were wrong the first time around, and we Federalists were right. My friend George Washington, my friend Alexander Hamilton, we Federalists were right. Madison doesn't love that. And then there's a second point in the opinion, where he talks about, in effect, the recent embarrassments, which are that under President Madison, the Capitol has burned to the ground. And so Marshall is calling attention to how the Federalists were right all along and how Madison has flipped and flopped. Here's what Madison would have preferred. Just an opinion saying, you know, whether it was right or wrong initially, it's settled now. It's precedent. We had the first bank, and no need to say more than that. So that's what Madison would have liked. But John Marshall is sticking it to Jefferson and Madison here, just as he did in a case called Marbury versus Madison. Who's the defendant in that case? It's James Madison as Thomas Jefferson's alter ego, Secretary of State. So in both Marbury versus Madison and in McCulloch versus Maryland, John Marshall is actually going after Jefferson and Madison just a bit. He does it in the most elegant way imaginable. Oh, he's so stylish and smooth. But there's a touch of partisanship here. And it's all the more brilliant because he's getting justices who have been appointed by Jefferson and by Madison to join this opinion. He gets a unanimous court. And that is no small feat. The second thing that he says is, given that Congress can create this bank for national security purposes, states can't undo it. And here, he's actually appealing to a Jeffersonian idea of sorts. It's an idea in the Declaration of Independence. No taxation without representation. It's wrong for Maryland to be able to tax this bank because they're taxing out-of-staters. They're, in effect, taxing New Yorkers because New Yorkers, through Congress, have given money to help create the bank, and so have people from Massachusetts and people from Connecticut. So you can't allow one state to undo what the Union has done. You can't allow the part to undo the whole. You can't allow, in effect, taxation of unrepresented out-of-staters. No taxation without representation. It's actually a Jeffersonian idea, and Marshall develops it in a beautiful and brilliant way. The most important thing about McCulloch is not its outcome. James Madison supported its outcome. Thomas Jefferson supported its outcome. Okay, federal government can have a bank. But the genius of McCulloch versus Maryland is how it goes about approaching the Constitution, which is holistically, structurally. Another genius is he keeps the court unanimous, he keeps it together. It's a very impressive judicial opinion, a tour de force in how one goes about interpreting the Constitution. Along the way, he makes beautiful arguments from text, from original intent. He has some precedential moves, gestures, but most important of all, it's a case about the structure of the Constitution as a whole and reading it to make good, practical sense in light of its basic fundamental purposes, chief of which is national security. New York has a law that allows a certain steamboat company basically monopoly privileges to run their steamboat back and forth across the Hudson River. The only problem is that Congress has a law that seems to authorize other people to do other things. And so one question is, in this case, are we going to go with the New York law that seems to give a monopoly to one steamboat company? Or are we going to go with this congressional law that seems to allow other companies to ply the river back and forth? Daniel Webster argued for national power, that Congress has the ability to regulate this transaction, even if it's not narrowly buying and selling. It's not commerce in the most narrow imaginable sense, that Congress's power to regulate commerce among the states includes navigation from one state to another. More generally, Congress has the power to regulate all sorts of things that involve more states than one. And Webster goes even a step further and says states have no role whatsoever in that. And Marshall, in his opinion, actually doesn't quite go that far. He doesn't need to go that far in order to give Webster the victory that Webster seeks. It's enough for Marshall to say, and it is what he does say, that federal power here is very broad, that the power to regulate commerce among the several states at a minimum includes navigation, and transportation from one state to another state. Structurally, it doesn't make sense to give individual states the ability to be the only regulators here, because the United States basically is almost entirely composed of states. So you're always going to be in one state or another state, but when you're trying to get from one state to another state, the entity that should be able to regulate that transaction is an entity where those states are both represented, and that's Congress. So Marshall says Congress here should have power and does have power. Commerce among the several states means commerce involving more states than one. And commerce includes navigation. And that's enough to decide the case, because Congress has passed a statute, and the statute allows this other steamboat company to do what it wants, and it in effect preempts, it trumps any effort by one state to give a monopoly. And why should it be New York rather than New Jersey? And suppose New Jersey gave a monopoly to some other steamboat company, and how are we to decide? Should we go with New York or New Jersey? Here's what Marshall doesn't say. He doesn't say states have no role whatsoever. He doesn't have to decide that. It's enough that this specific monopoly law that New York has passed conflicts with this specific congressional statute. Maybe if there weren't a congressional statute on the books, maybe it might be a different case. He doesn't need to decide that. Webster wants him to go even further in a nationalist direction, but Marshall decides the case at hand. And he decides it in favor of a broad view of federal power. John Marshall is the last founder. He's a young man of the American Revolution. And as a young man, he enlists and he's at Washington's side. He's an aide-de-camp. He's at Valley Forge. So he is an American revolutionary who hitches his political star to his great mentors, George Washington and later Alexander Hamilton. He's a self-taught lawyer. He's an interesting combination of American aristocracy and American self-making. He's a Randolph from Virginia, but he's not quite in the tidewater. He's a backcountry fellow. He's a cousin of Thomas Jefferson's. They have some things in common. They're both quite gifted politically. Marshall has a great personality, a winning personality. People like him. He's very charming. He's a beautiful writer. And he lasts a long time in political life. At a young age, he's with Washington in the American Revolution. And then he becomes a leading diplomat and wins honor in America for defending America's interests in France. He's a young member of Congress. And unlike many other people in his party, he's not completely destroyed politically by the Jeffersonian Revolution. He becomes, at the end of the Adams administration, Secretary of State, which is a very high position. This is an era in which many secretaries of state go on to be presidents of the United States. He's the brightest Federalist star, and he could have possibly been president of the United States in his own right, but instead, at a very young age, he gets put into the judiciary as the Chief Justice of the United States. And he stays there for a very long time. Even though the political tide is against him, the Federalist Party basically collapses. The last Federalist president was John Adams, and we're going to get Jeffersonians one after another, and John Marshall is not quite a Jeffersonian, and all the people joining his court are basically Jeffersonians, and he becomes their friend. He works with them. He creates a very powerful court that stands for things, national power most of all, and he stays. Jefferson leaves the presidency. Washington leaves the presidency after 8 years. Adams after 4. Jefferson after 8. Madison after 8. Monroe after 8. No one stays more than 8 years. That's a good run, 8 years. And Marshall is there for more than 30. And at the end of his service, he's the last founder standing, the last founder still in public life, because he was very young at the time of the American Revolution. He actually spoke on behalf of the Constitution in 1788 in the Virginia Ratifying Convention. So he was there at Valley Forge and there for the Constitution as a young man, and now at the very end of his life, everyone else has basically died. Washington has died, Franklin has died, Adams has died, Jefferson has died, and he's still around. James Madison is still alive, but has retired from public life, and John Marshall is on the court day in and day out, working with justices appointed by many different presidents and creating the modern Supreme Court. He's the father of the modern Supreme Court and the last of the founders. Maybe not women in song, but John Marshall is a charmer. Here are some things you need to understand. before he comes along, the court actually doesn't even issue opinions of the court as such. It's every man for himself. Justices say, well, I think this, and then another justice says, I think that. They're called seriatim opinions. They don't even always write it down, and no one else necessarily writes it down. Marshall comes along and says, we're going to speak with one voice. We're going to write things down. We're actually going to make sure that what we write down actually gets out there to the legal community. We want to make sure that it's properly published. So he creates the idea of a court rather than individual justices. That's from the beginning. Then he says, not only are we going to write these opinions, we're going to try to do them collectively, and ideally we're going to try to speak wherever possible with one voice. That voice will be my voice. I'll listen to everyone and try to find the common ground around the table and articulate that. He's a beautiful stylist, and he's a very good listener. So he listens to everyone, and he finds that sweet spot, that common ground, and he puts it into very simple, powerful prose. He's a very good stylist. He has Lincoln-like skills that way. And he's a charmer. And he's got a very winning personality, and the justices are far from home, you see. So he creates a kind of home away from home. They're living together. There's a boarding house, and it's maybe like your favorite dorm in college or something, and they're hanging out together, and yes, they have a drink at dinner, and that lubricates the social interaction. There's a country western song, it's 5 o'clock somewhere, so somewhere, Marshall says it's drinking time, so maybe we could even start a little early today. The sun hasn't quite gone down yet, but we've put in a hard day's work. And he charms people who were appointed by Jefferson and Jeffersonian presidents. And Jefferson hates this because he thinks John Marshall has basically corrupted the judiciary, and Jefferson, in his own way, has all sorts of political skills. He's able to get his allies to do what he wants, and so is John Marshall. Marshall's main objective as Chief Justice is to survive. He inherits a court that's very, very weak. Before he comes along, the court does not speak with one voice, does not have written opinions, has decided very few interesting issues, important issues. The only important constitutional case the Supreme Court has ever really decided of real consequence before Marshall comes along, a case called Chisholm versus Georgia, is immediately met with a constitutional amendment overturning it. Justices have left the Supreme Court to serve in other positions, to be not just governor of New York, which might be a good job, but to be justices on their state Supreme Courts. That's a better gig than being on the U.S. Supreme Court because you get to sleep in your own bed and you don't have to ride circuit. So he inherits a very weak Supreme Court, a Supreme Court that is tainted by its association with the very unpopular Sedition Act, which has made it a crime to criticize the Jeffersonians. And justices who are on the Supreme Court, on circuit, have cheerfully enforced this statute. So he inherits a court that is at low ebb. And he makes it into something, but his first task is just to survive, because his party is the minority party, the Federalist Party. His branch is the least powerful branch of the three. It doesn't have the purse that the Congress has, the power to spend money. It doesn't have the sword that the president has. And the other branches are basically allied. Jefferson controls not just the presidency, but basically the House and the Senate. Marshall just has the judiciary, and his party is discredited, so his first goal is just to survive, not to pick fights that he can't win. So he pokes the bear a bit, Jefferson, but he never provokes a confrontation that will result in a direct clash, and he stays. And gradually, he basically builds this court. And presidents come and presidents go, and he is Chief Justice. And justices, one by one, come to him, and he creates a court. And he basically sides with Congress, with the federal government, against states, because that's a game he can win. If he's defending what Congress has done, the court can beat an individual state. If he time and again tries to go against what the national government has done, ooh, that's probably the odds then tip against him. Yes, in one case called Marbury versus Madison, he holds unconstitutional a federal statute, but actually even then Congress isn't upset with him at all for complicated reasons. In fact, Congress didn't even try to do what Marshall said it was trying to do. So Marshall says, you can't make us take original jurisdiction, so there. And Congress is saying, actually, we didn't even want you to take original jurisdiction in that case, so fine by us. So Marshall, even in the one case where he asserts power against Congress, is not really picking a fight with existing congressmen. Marshall saw the potential of this institution in embryo, and he made it real. And I'm not sure anyone else could have done that. I think John Marshall would be pleasantly surprised at just how powerful the Supreme Court is, and the judiciary in general. In more than 30 years on the court, John Marshall strikes down one act of Congress. Today, the Supreme Court invalidates 2 acts of Congress a year, and big ones, Voting Rights Act, campaign finance reform, and when it's not invalidating big acts of Congress, it's coming close to invalidating big acts of Congress, like Obamacare. That would be a surprise, perhaps, to John Marshall, just how powerful judicial review has become. Another surprise to him, I think it would be a pleasant surprise, is how the Supreme Court has remained less partisan than the other branches. Oh, I'd love to know the real backstory of Marbury versus Madison, because the case is absolutely fascinating, but not really for what it says, if you just read, but for all the political maneuvering. When you read it, it's about writs of mandamus, and who cares? But I would love to know just how much political maneuvering there was, and how much of what I'm reading into the opinion really is there. Am I reading into it too much? I think that's the case I'd probably, and that's Marshall at the very beginning, and he's a little bit bolder in this case. He's a little bit more of a partisan in this case. He learns, I think, actually to dial it down a bit with time. I am on record as saying Marbury is overrated just because judicial review was established before John Marshall came along, and it didn't really accelerate until long after the Marshall era. All that said, the politics behind Marbury versus Madison are fascinating to me, and he really does seem to me to be wily Odysseus.
Last question. Was John Marshall right in how he saw the role of the Supreme Court?
I think John Marshall was basically right in his vision, because I live in his world, and it's hard for me to imagine, actually, a different world. So I live in a world of judicial review that he helped cement. I live in a world of a powerful Supreme Court that he helped create. I live in a world of broad federal power that he helped establish.